Mr. Schwartz, why did you file this eviction?
Holly Rodriguez doesn't have a lease with me. She's my child's mother. Um, and there was a CPS case involved. I believe that CPS advised me to keep Holly away from our daughter.
All right, explain the living situation between you and the defendant. Do you cohabitate in the same unit?
During her pregnancy, on and off, she was living with me until December 13th. I provided her with a notice to vacate. On the 9th, she left. On the 10th, she was detained by police and sent to a hospital. After that, she was there for 3 to 5 days, and then CPS was involved. At that point, they put up a safety monitoring, so she couldn't return to the property at that point. We tried to figure things out after the safety monitoring was dropped. And then on April 26th was the last day that she was in the residency. On April 29th, I discovered her using drugs again and talked to the CPS worker. CPS worker advised me to keep our daughter away from her. At that time, let's see, on May 2nd, she came to the house, wanting to see our daughter. The police were called. I asked them if they could issue her a warning with trespassing. They said they couldn't because she stayed at the property on April 26th and she had some of her belongings there, and that I had to file another notice to vacate. I did that on the 8th. She showed up on that day. Asking to see her daughter. And she called the police. The police told me that the notice to vacate didn't qualify. So I sought a paralegal to help me write up a notice to vacate. I sent that to her certified mail, standard mail.
Mr. Schwartz, Mr. Schwartz,
Yeah.
where did you send the notice to vacate?
To the residency she was staying at during the safety monitoring.
And what day did you mail that notice to vacate?
On May 11th.
And when did she enter the residency?
When was the last time she entered the residency?
Yeah, because in your summary, you
April
said,
26th.
is that when she entered or when she got out of treatment?
No, so she went into treatment on January 10th.
Okay.
And then we tried to work out, co-parenting, and we tried to work out different therapy sessions, and it wasn't working out. After I discovered her using drugs again.
Yeah, that's Mr. Schwartz. Mr. Schwartz, this is
Yeah.
where your story is confusing me. The
Okay.
first thing you have to establish, setting aside all of the drama, is
Okay.
that she is a tenant in your home. So start with that. Does she currently reside in something that you're the owner of, in your home, in an apartment,
No.
complex? Does she live with you or anything you own?
No.
Then if that's not the case, you cannot evict her.
Well, that's what
Mr. Schwartz, I understand that police gave you information. Police, with respect to them, they're not lawyers, they're not judges. They don't actually know what they're talking about when it comes to property law. Okay.
Correct. Yes.
If she is not someone who resides with you, you cannot evict her.
Okay.
That is the ultimate first step of question. Like, is she a tenant? If she's not, there's nothing you can do in an eviction court with her.
Okay.
Okay. There may be other things that you need to do. And and I'd say for you in a similar situation earlier, or not a similar situation, just another person who was kind of in a different housing situation, for both you and Ms. Rodriguez, for you as well, the Travis County Law Library or any of the resources we put about housing may be useful. You have a situation in which you might have some belongings with each other, it sounds like, and certainly understand that you're going to be co-parenting, and good luck to you both for that. Your child is always the most important part of that. But Mr. Schwartz, if she is not a tenant or a resident with you, then there is no eviction that I can give because she hasn't done anything to be evicted. It just may be some other type of dispute between the parties.
Yes, correct. So when she comes onto my property, I just would like to have her warned with trespassing. And they said
And-
that I wasn't allowed to do that.
My belongings are at your house.
Ms. Rodriguez, Mr. Schwartz, if she is not a tenant and she does not live with you, she has no right to be there. It
Correct.
doesn't matter if she long ago left things with you. Please call a lawyer about what to do if someone has abandoned items on your property, but is not a
Correct.
resident and has never been a tenant.
Yes, that's what I said.
So say that to a lawyer and they can give you some paperwork that is different. There may be a different legal mechanism you need to pursue, but eviction would not be, it wouldn't fit the facts of this situation.
Yeah, that's what I said. Yep.
All right. Well then today, Mr. Schwartz, the court would, it would be dismissed. It would be a judgment for the defendant because there is no evidence of a tenancy between the parties.
Correct.
All right. Now, Mr. Schwartz, I know this one's a bit strange because everyone agrees on the fact pattern here. You can't appeal my decision, right? If you believe you actually have, like, let's say you talk to a lawyer and you think, no, I gave information incorrectly or I do satisfy it, you can appeal this decision. You can also start the process over. Ms. Rodriguez, though you have essentially won and prevailed today, you can also appeal my decision. Parties are free to negotiate with themselves. Again, I understand you probably will have to keep communicating with each other for the sake of your child. Okay.
Correct.
All right.
Okay.
Thank you very, very much. Then, Mr. Schwartz, can I answer any questions?
Nope.
All right, Ms. Rodriguez, any questions?
I have a question directly for Jordan. If
Okay,
that's
well, to ask him directly outside of court. We're gonna move on to the next case, y'all.
Thank
Sure,
you.
I don't want to air y'all's privacy. All right, y'all have a nice day. All parties are
Yep.
excused. Thank you.
Thanks.
Bye.
Bye-bye.
All right. Did anyone check in for the defendant?
No, Judge.
Okay, so we just have a plaintiff. All right, Ms. Davila, why are you wishing to evict Mr. Corpus?
You need to talk loud. She doesn't hear very well.
I was gonna talk for her if she's
That's
right
fine.
here.
You
Can
can,
she
you can
do
be
that?
her representative. Just tell me why
Okay,
that's why
thank
she
you.
filed the eviction.
Okay, we filed it, ma'am, because we're trying to get our home repaired because we had a house fire on April the 14th. And we had to leave the premises. We had to leave. It was uninhabitable. That's what they said, the fire people, the arsonists, the people, everybody that went there from the fire department and the APD also. I have the two cases written down, the files on both. And they told us to move out so they could start going in there and taking the house apart, you know, so they can redo all the inside because they had to tear down everything that like walls and stuff, sheet rock, insulin, everything.
Davila, Ma'am, ma'am, do you have a lease with the defendant, Mr. Corpus? Yes or no?
No, word of
How
mouth,
can
he's
you
my
evict someone
son,
if they're not your tenant?
He's biological son.
biological son, and I was told to, the only way I could get him out of there, because we need to have our home fixed, and nobody's gonna go in there because he's an obstacle, and they're refusing to go in there and do anything for our home. So we're
Okay.
at my sister's
Okay,
relocated.
all right, all right. If I understand what you're trying to tell me, it sounds like your son lives with the plaintiff and she's moving out and he won't leave?
Myself, my son, and her live there at that house, and we're not there. We're in Kyle. We had to relocate. We had to leave, ma'am. They told us to go because it was not good to live in that house because it has to be redone in the inside. And he's refused to leave since
Okay,
then.
ma'am. Did you give him a written notice to vacate?
I sent this, I filed this, and I
Not what
told
you
him
filed
the
with the
word
court,
of mouth.
Ma'am,
No.
before
Oh.
you came to the court, did you in writing give him a written notice that said you have to move out and you have to be moved out by this time with a date?
No, I didn't. I waited to do the eviction. I thought that's what the police told me to do.
Ms.
They
Davila,
told me I
I'm
had
gonna
to do
refer
that.
you to our law library. I'm afraid today I'm gonna have to dismiss it for lack of service. If you wish to
Oh my
evict someone,
God.
you have to give him a specific type of written notice.
But they told me to go to your.
Ma'am, my speak, I'm the witness. I'm the sister, my mother.
It does not matter. I please hear what the court wants to give you some information.
The insurance, the homeowner's
Please.
insurance is willing to give up on us because they need to get that done.
I believe that
My
that is true, but I cannot evict someone if you didn't notify them they're being evicted.
Well, they were served.
That there's no way around it. State law requires a
There's no
written
way of
notice.
serving it. You have to
Well, I
write,
told them.
but then you have to put it in writing. You need to get out. We waited all this time for nothing because you should have done that.
Well, how was I to know? I thought that's what
Okay,
this meant.
ladies. I understand families can be frustrated, especially if you're trying to get your son to leave. But I want to refer you, please, to the Travis County Law Library. That website that I flashed up at the beginning, they can absolutely assist you as a regular person who is not a lawyer, who is going through a difficult situation about the proper steps to give notice to your son. Okay, Ms. Davila, you've become muted. I want to be able to hear your questions. Ms. Davila, there you go.
He's mentally.
He's
challenged.
mentally challenged. We went through an aging department. I'll send old people because he's abusive verbally to my mom physically. He's been breaking things and he destroyed the house more. We've had some MHMR cases, police, MHMR, everything, ma'am, for his violence that he has.
Yeah,
My mom's 89.
Please contact an attorney. For
yeah.
so many things you're
Yeah.
saying to me concern me, for your safety, for his safety, for proper following the law. Please
Yesterday he had a
contact
gun.
any of those legal aid services that we highlighted about what to do if you're trying to evict
Don't
someone.
antagonize you, please.
They're very
Okay.
specific procedures that have to be
Well,
followed.
it just, what do I do about this, ma'am? I went over, they call me because there's neighbors that attended, be looking in the house, and he had a gun. He
Ms.
was
Davila, I
threatening one of
cannot
them.
give you advice as to how to proceed. If you are
Okay.
concerned for safety, if anyone is bringing out
For
a
safety.
firearm, call the police. That's not legal
Yeah.
advice. That's practical
I'm not
information.
there, that's what's wrong, see, I'm not there at the house.
Okay.
Kyle,
Contact everyone in the law and legal aid. I would say today, Ms. Davila, the court would dismiss for lack of service. It doesn't appear that you gave any type of notification to your son before you filed the eviction. And
He should.
okay,
there's some type of notice
what
that's
do I do
required.
from there
So
on?
when do we have to go redo this again or are you gonna give us another court date?
Ms. Davila, the case is being dismissed today. You have two things you can do. Well, you have several things you can do. You can appeal my decision, right? I'm finding in favor of the defendant, Mr. Corpus, because you did not notify him before you filed the suit. So it's called a lack of service. That's the reason
Okay.
I'm finding in favor of your son, because you did not tell him before you sued him that you wanted him to move out. And per your information, you got to give him a notice to
No, you,
vacate.
I thought this is
Now,
what that was.
you can appeal this decision.
You've heard me tell
You
him over
can
and go
start
ahead,
the
ma'am.
whole thing over. You can do something else if he leaves, right? I'd say to start, as a general rule, you might want to contact any of those legal aid groups. And a free, obvious one that I will highlight is the Travis County Law Library. They have an entire section and they have lawyers on staff who can just answer your questions for your specific fact pattern. As the
All right.
judge, I'm only allowed to say, here's a map, there's all these roads on it. That lawyer can look at the map and say, for you, you're going to want to go this route, because this one's got a bunch of toll roads in it. I can't do that for you, Ms. Davila.
Okay.
Okay,
Okay.
I understand. That's
All right.
fine.
Very, very best of luck to you.
What
Don't
about the
wait.
appeal?
The minute you're done with Zoom, you
You
can
have to
contact any of
appeal
those
it
providers,
yourself,
okay?
and that document.
Ms. Davila? Any final questions, ma'am? Otherwise, you're all excused for the day. All right. I would put the appeal bond of $100. Stephanie, by statute, we would put that at $250 for rent.
Yes, Judge.
All right, all parties to that matter are excused. All right, Ms. Stevenson, why was this case filed?
This is for non-payment of rent,
How much is the rent?
$1,695.
Any subsidy?
No.
Okay, what months are unpaid?
Partial March, April, May, and then prorated through today, the total comes to $3,785.26.
Is this Shakir's property?
It is.
And was a 30-day notice given?
Yes, a notice to pay or vacate was delivered on April the 10th.
Good afternoon, Mr. Martinez. Thank you for being here.
Good afternoon.
Ms. Stevens is here at the landlord. She says this case is one related to a financial situation, so only an allegation of non-payment or a partial payment and then non-payment. So my first question is always, is the amount of rent correct? Is it $1,695?
Correct. Yes.
Okay. And then Ms. Stevenson says that partial payment was made in March, but that April, May, and June remain unpaid. Is that also correct?
Yes, it is correct, Your Honor.
All right. Well, Mr. Martinez, with that information, the landlord will meet their burden today to win the case. Can I answer any questions for you? I always like to tell you exactly what happens next, kind of a timeline of things, but immediately any questions?
Yes, I do have some questions. I already returned the keys. Like the apartment is empty. I already left. I just wanted to like want to know the next step. Like, is it a like a plan of payments or something? Like, how does this work?
Okay, that's a great question, Mr. Martinez. So what'll happen now is the court would enter a judgment. I would award what they sought, which is $3,785. And I'm not going to bother with change, but Steven said, I appreciate it, but my clerks like me. So it's just going to be, you'll see 37.85. Now, Mr. Martinez, added to that will be their filing fee. So it costs the landlord $83 to pay to file the case. They had to pay a small service fee for the constable. So you'll see that added on. Typically, it's usually $130, $160 or so. And then that would accrue interest every year going on at 6.75%. Now, you can work out a negotiation with the landlord to pay that off in any way, shape, or form that you and the landlord come to an agreement. The court doesn't say you have to make payments of a certain amount or that you have to do this or that. We just say the money is owed and it's official, and that's it. You can still appeal this decision today, as can Ms. Stevenson or her client or her landlord, the owner of the landlord's company. You each have 5 days to do that. If you don't do anything at all, Mr. Martinez, that amount of money becomes official and owed on day 6. And potentially it could be found by additional landlords that might have some impact on your credit. You've already moved out, so that won't have any impact on the right for a possession. But if you had not vacated yet, on day 6 is the day the landlord can legally get a writ of possession and re-enter the unit. And if you had still been there, if you still had items in it, that's when they can remove those things and people from the unit.
Oh yeah, everything is
And
already out.
Yeah, if you've already
Okay.
moved out, that's kind of a moot point. But in terms of the money part, the court won't do anything to enforce how the money is paid. We just say that this is the amount as of now and it's owed. And then it's totally up. You can contact Ms. Stevenson. Ms. Stevenson, right now, is there anyone you would recommend Mr. Martinez reach out to if he wants to try to arrange
Yes.
payment?
Jenny, the property manager, or you can email me as well. And my email and phone number should be on the eviction paperwork.
Mr. Martinez, if you can't find it, you can just, when we're done with Zoom, you can call the main line to our court, which is on that paperwork, and we'll give you all the information we have for the plaintiff.
All right, sounds good, Your Honor. Thank you.
All right, good luck, Mr. Martinez. Thank you for coming. Ms. Stevenson, if you have no other matters, all parties are excused. All right, Ms. Warwick, why was this case filed?
This case was filed for non-payment of rent.
Okay, and how much is the monthly rent?
It's $1,500.
Even 1500?
Yes, ma'am.
All right, is there any portion paid by the government?
No, ma'am.
All right, what months will remain unpaid?
May and prorated June.
Okay. Is this CARES Act property?
No, ma'am.
Was May the first time he was late on the rent?
No, ma'am.
Was a notice to vacate provided
Yes, ma'am. On May 4th.
on May 4th?
Yes, ma'am.
All right, and how was it delivered?
To the resident.
Mail, email, hand delivery?
Oh, hand delivered.
Hand delivery. Okay.
Yes, ma'am.
All right, good afternoon, Mr. Hernandez.
Hello.
Thank you for being with us. Thank you for both of you for your patience. I know we've already been on our docket for an hour. Mr. Hernandez, Ms. Warwick says this case, as I've heard from some others today, a financial situation, which those are no fun, I understand. So my first question, Mr. Hernandez, is the monthly rental amount correct? Is it $1,500?
That is correct.
Okay, and then do May and now June remain unpaid?
Yeah, but I do have money for last month. If I was to yeah. So my goal is to be to get everything resolved and paid up, or to work on getting a moving agreement.
All right, have you spoken to anyone with the landlord about that?
No, I haven't. I wrote an email. Was trying to do payments, and I wrote him an email on June 12th or May 12th. Letting them know when I would have it all paid, but they were not willing to cooperate with me. I also had financial assistance that I was moved into that she had told me she would work with, and then she decided that she couldn't work with them because the process and what was it? They're having problems communicating because I needed a DocuSign signed up by the assistant, Labwen, financial assistant. And they wouldn't sign the DocuSign. And I also had a witness when they said that she was willing to help with that. I have a witness here that I can put on that heard her say that to me the day I was inquiring about the apartment.
Unfortunately, Mr. Hernandez, it would not be as an effective defense. So if it's unpaid contract, it's pretty strict liability and things. However, I will say, and Ms. Warwick, you're welcome to add information here. I don't know. She may not know, Mr. Hernandez. She's property manager, and sometimes the decisions come from someone above her. I will just say for both of you, sometimes what I hear, Mr. Hernandez, is after the judgment is given, the landlord is then more willing to work with the defendant because they already have the eviction done. And therefore, it's kind of like they know they have something and they can then work with you. They may not. But you do have at least 5 days after today to either negotiate with the landlord or appeal. And then if you appeal, lots of things can still take place, okay? If you do nothing,
Yeah, for right now.
nothing on day 6, the judgment would become final, and that is the soonest the landlord can seek what's known as the writ of possession. And that is the legal way in which they say, hey, you haven't left, so today we're going to remove you and your items from the premises. And that's a gentle, it's a peaceful thing, but they cannot do it before those 5 days pass.
And then when they get the writ of possession, how
Mhm.
long do they have to, do I have to actually get my stuff out at that point? That same day, or is it like a couple days more?
It's within 24 hours. Constable will give you a notice and post it, and if you're not gone, constable comes in the next day with the landlord and they literally backs everything up and move it out. There's no additional hesitation.
Okay,
Now,
so
I will give you some extra information, Mr. Hernandez, and Ms. Warwick, just, you probably already know this, but the landlord can ask me for that the day following the appeals period, so on day 6, and they have up to 60 days to do it. So this is where, if you are in good relationship or contact with the landlord, sometimes they'll say, okay, we can sue it on day 6, but we'll wait till day 10 to give you through the end of the weekend. Or I'll just say that is their discretion. Legally, they can seek it on day 6. They have up to 60 days to do so before they have to start a brand new eviction filing against you. Okay,
okay.
all right. Well, what I would calculate for May, and then Ms. Warwick, what day is the rent due under the lease?
It's due on the 1st.
Okay. I get 200, is that right?
Yes, ma'am.
How weird. You have absolutely perfect numbers, Mr. Hernandez, Ms. Warwick. When I divide 1,500 by 30, it's $50 a day. So for 4 days, it's $200. That is the easiest judgment I've written all day. Judgment for the plaintiff for $1,700. That's June of 4 days at 200, and then all of May at 1,500. Either party can appeal. I'll set the appeal bond equal to 1 month of rent. That's 1,500. And Mr. Hernandez, for you, for others, if you want to appeal and you did not have that much money, which you're being evicted for non-payment, that's a possibility, you might still qualify to appeal for free with an affidavit of inability. There are specific restrictions about who can apply or who can qualify for it, but we always send that information out immediately. All right. Any questions, Mr. Hernandez?
That was it.
All right, Ms. Warwick, any questions?
No, but just for work purposes, my last name is with an A, not an O.
Oh, okay. Thank you.
Yes, ma'am.
All right. Nothing else, then all parties are excused. Thank you very much.
Thank you, Judge.
Have a good day. All right. 26816. Chisos Basin Properties versus Brittany Gatan Townsend. Do I have someone here on behalf of Chisos Basin?
Yes, Your Honor, that's myself, Susan Armstrong.
Good afternoon, Ms. Armstrong, and are you counsel or owner?
I am the owner.
Do I have anyone here on behalf of Brittany Gatan Townsend? Anyone here on behalf of Ms. Townsend? Ms. Townsend, I see someone with your name in the courtroom. If you unmute, I can hear you, but right now we're not able to.
Sorry, yep,
Oh, no, there you go.
it just took me a second.
Yeah,
I'm
you're
here.
absolutely fine. All right, good afternoon to you both. All right, Ms. Armstrong, why was this case filed?
For non-payment of rent, Your Honor.
All right, how much is the rent?
$5,050.
5050?
Yes.
All right, is there any portion from the government?
No.
What months of back rent are sought?
All of May and prorated of June.
Was May the first time tenant had been late with the rent?
First and only time, yes. That was the date of move-in as well.
All right. Was a pay or vacate notice provided to the tenant?
Yes, Your Honor, on May the 13th. Or
Okay.
I'm sorry, it was on, yes, I'm sorry, May the 13th.
Okay. Good afternoon, Ms. Townsend.
Hi.
Thank you for being here. So I've heard Ms. Armstrong said this is case similar to some of the others we've heard today about non-payment. So as with all parties, I like to ask, is the monthly rent amount correct? Is it $5,550?
No,
How much is the monthly rent?
5,000.
Ms. Armstrong?
Your Honor, there's a $50 pet rent as well. So without rent, or I'm sorry, without pets, it's 5,000. With pets, she has 2. It is 50/50. 5,000.
All right, we call it 5,000. So it's rent. Cool, we're all on that. Now, Ms. Townsend, have you paid May and June?
No, I am in the process of retaining counsel through TRLA. So I was wondering if I could just get a week continuance in order to wrap that up.
No, these are time sensitive, Ms. Townsend, but you absolutely can
Okay.
appeal. Let TRLA know that you have an eviction. Quite often,
Yeah,
this is anecdotal, y'all.
sure.
But after you tell them that today you had your eviction and it was found against you, that may speed up the process by which they can give you
Sure.
assistance. So just, anecdotally, we've had people say, we told no, but the day we told them we got evicted, suddenly they were there. This was just an appeal. Okay.
Okay.
All right. So May and June. So for May, if I divide, well, that's the full 5,000. For June, I'm getting 166 a day, and for 4 days is 666. All right, I did it twice. I'm going to ignore all the change, y'all. So judgment today for the plaintiff will be for $5,666 plus cost of court. Either party can appeal. Appeal bond will be $5,000. That's the month of rent. All right. And then same thing applies. Parties have 5 days beginning tomorrow for appeal. If you take no action, it becomes final on the 6th. You'll also have 5 days if you come to some negotiation and let us know. Otherwise, very best of luck to everyone, okay?
Thank you.
Thank you both very much, and thank you for your patience. I know you've been with us for about an hour and a
No
half already
problem.
online, so thank y'all. Have a good afternoon.
Thank you. Bye.